Well, it's a pleasure and an honor to have Julie Kelly, who never gives up, which is a fantastic characteristic. And I want to thank you, Julie. So I read your piece about what they're doing in Washington, D.C. Why don't you speak about what they're doing and all the rest of this that they're doing and the context for it in terms of history, in terms of past prosecutions, past elections. Let me just say this to you, Julie. I don't know how a judge can expect not to be part of the political process when she allows herself to be part of the political process. In other words, these district judges or these state judges, they can't allow themselves to be used, and some of them want to be used by the government to make decisions that have an effect on an election, and then say, okay, and meanwhile, the person we're making decisions about, he has to keep his mouth shut, and you damn well better not criticize me by name either. That's not tolerable, is it?
It absolutely isn't. And I will tell you, Mark, the American people are about to get a big dose of what I've watched this D.C. District Court, these prosecutors, these judges do for the past 2 years in these January 6 cases that you and I have talked about. Thankfully, you started covering my work on January 6th. You were one of the first, so I'm so grateful for your covering my work.
Because I'm grateful for you doing the work.
Too, well, I mean, my jaw just routinely would drop to the floor when I would read the filings and I would see these prosecutors in action, but more importantly, what the judges were saying and what they were allowing. And as you know, Judge Tanya Chutkan is one of the worst. You would be hard-pressed to find a more conflicted, biased judge. I'll tell you, Mark, I stumbled into her courtroom one day during a break for the Proud Boys trial, and she was sentencing the one man who had the gall to go to trial on 4 misdemeanors. Most January 6 defendants plead out if she is the judge because she is so tough and harsh. Of course, she hands down the harshest sentences. And I watched her just drip with condescension and contempt for this man from Alabama who was in the Capitol for 11 minutes. You could sense, it was palpable, the contempt, the hatred that she has for Trump supporters and people who dared to come to their nation's capital and protest Joe Biden's election. I've seen her in action, and I'm telling you, there's no way she should be assigned to this case. Of course, she authored the 2021 decision that denied Trump's executive privilege protections, forcing him to produce records to the illicit January 6th Select Committee. Her fingerprints are all over the worst aspects of this January 6th criminal prosecution at DOJ and now Jack Smith. And here she is. We're expected to believe that she is going to be a fair arbiter in this situation, this matter. She just isn't, and she's already shown that she's not.
And she's not going to let go of this case, even though I would have filed for a venue change, too, because she decides on that, doesn't she?
She does. And, of course, as you know, every single D.C. judge has denied every change of venue motion filed by a January 6th defendant, even in high-profile cases like the Proud Boys and Oath Keepers. They insist that a fair jury can be seated, even though DOJ has a near-perfect conviction rate in January 6th trials. So this is the rigged Banana Republic-style climate that Donald Trump now finds himself in.
And speaking of Banana Republic, just for plain English, this 18 U.S.C. 1512, this Enron statute, was passed to deal with what they saw was a gap in the Enron cases after the fact. And that is, you had executives who were accused of destroying documents that Congress wanted and so forth. It has no application to this case. We talk about the Ku Klux Klan Act that they're using and other stuff. And in fact, this was on appeal, the use of this particular statute. One of the judges was very skeptical, but they said, okay, I'll go along. It's eventually going to get to the Supreme Court. You don't take a statute like that and apply it to a candidate for president, the former president of the United States, willy-nilly, do you?
Well, in this case, you absolutely do, because they have successfully tried this obstruction felony in numerous cases. It has resulted in multiple plea agreements. Of course, the most famous January 6th obstruction victim is Jacob Chansley, who spent 41 months in jail, not just was sentenced to 41 months, Mark, but spent months in prison, denied release simply because he was charged with this obstruction felony. So it is on appeal. It has been appealed. There was what was called a splintered ruling. That was how one of the judges described it. And now two defense attorneys have filed petitions with the Supreme Court to hear the appeal and, of course, just hear how this has been weaponized by DOJ. It's a 20-year-old statute. It's never been used this way. In fact, the judge for its pan, a Biden-appointed judge on the D.C. Appellate Court, admitted it had never been used in this manner before, that it was a novel use of the statute. But this is just one way the DOJ is setting precedent to criminalize political dissent, and now applying this felony that's been slapped against more than 300 January 6th defendants against President Trump.
I think the only hope here, and it's not a slam dunk, that's for sure, is to try and get this case, or a case, in front of the Supreme Court for this reason. I've been harking on this now for a couple of weeks. People are starting to pick up on it, Julie. I went back and I read the 1973 decision from the Office of Legal Counsel, the Nixon Justice Department, and then the 2000 decision from the Clinton Justice Department, the Office of Legal Counsel, which is the brain trust of the Department of Justice. Scalia used to be the Assistant Attorney General of that office. Rehnquist was the Assistant Attorney General. And I read it. I've read it before. And they talk about how a president can't be indicted or shouldn't be indicted because it's not possible for him to run the executive branch with all the responsibilities involved in that, plus defend his liberty. Defend his liberty. They said it's different with a civil case, obviously, because he's not defending his liberty. But here, the Constitution creates a number of barriers for the government. It also creates a number of evidentiary tools, and statutes do too. And a defendant has to spend an enormous amount of time with their lawyers in order to fight for their liberty and stay out of prison. So you can't have a president doing that. And they said the stigma that attaches to being indicted while you're president. So I'm looking at this and I'm saying, I understand Donald Trump or any candidate's not president, but he's running for president. And he cannot possibly defend himself, not just against one slew of indictments, what are going to be 4 different slews of indictments, where they're tripping over each other on court dates, on the calendar of the courts. He has to work with his lawyers to go through videotapes. He has to work with his lawyers to go through over 1 million pages of documents, and at the same time have a chance of running for president of the United States. Julie Kelly, really, it's not possible for somebody to defend themselves against what will be 100 charges, any one of which can put them in federal prison or state prison, and run for president. Isn't that the goal here, to cripple him?
Yes, it absolutely is. I mean, if you look at the classified documents case in southern Florida, there's already 1 million pages of discovery that defense counsel has been warned about, in addition to 3 years' worth of security footage from Mar-a-Lago. 9 months that they took from the security footage, DOJ and FBI took, from multiple cameras. So they have to look at all of that in the classified documents case. Then you turn to this case, and it will be more discovery, more evidence in this case because of the number of witnesses and all of the transcripts. And, I mean, this is a far more wide-ranging case. Now, in the classified documents case, Donald Trump has to go to a secure facility with his defense attorneys to look at these alleged classified records. He can't see them in his home. He can't take notes. They can't be shared. Some of the files he's not even allowed to see under a pending protective order. So not only are they overwhelming him with these criminal cases and the amount of discovery, they are going out of their way to limit his ability to even see the evidence against him, which was the essence of this new protective order, basically a gag order, but also requiring even regular discovery materials to be classified, to be designated as sensitive. So he can't access them. They can't post them in any hearings or motions or anything as this heads towards trial. They are making it impossible not just to run for president, but more importantly, Mark, to defend himself, as any American citizen should be able to do. That's how malicious, abusive, and retaliatory this Department of Justice is. And Judge Chutkan is going to let them get away with it. Judge Aileen Cannon, not so much.
2 points. You raise executive privilege and then attorney-client privilege, and Trump was denied both. And both of those should have been allowed. The attorney-client privilege that was litigated in secret, it wasn't even litigated. It was presented in secret. The judge orders that significant amounts of information, and his lead lawyer in the documents case, he can testify, present his notes, serves as the basis for most of the charges. And it's still under seal. Even Trump hasn't seen it. And then you have executive privilege. You talk about this other judge. When they waived executive privilege for Trump, and by the way, Biden refused to insist on it for Trump, that is what allowed, in essence, Mike Pence's notes and his testimony to come into the grand jury. So here, Trump's confidential, privileged discussions with his attorneys, that goes to the grand jury, and Trump's privileged discussions with his vice president, that goes to the grand jury. Have you ever heard anything so outrageous in your life?
I haven't. It's just remarkable. And, Mark, and thank you for covering my work, but people can check out my Substack, Declassified with Julie Kelly, and I give a good background into the classified documents case and Judge Aileen Cannon's involvement there. And what she called out today was something very important, and that is the fact that the Department of Justice and then Jack Smith conducted 99% of the classified documents investigation in Washington, D.C. That's how they got D.C. Chief Judge Beryl Howell, another Obama judge who used to be a Democratic Senate staffer, brazen hatred towards Donald Trump and his supporters. She made two key decisions. First of all, piercing the attorney-client privilege between Trump and Evan Corcoran, his attorney, forcing Corcoran then to testify before this D.C. grand jury and produce his notes and documents, private records between the former president and his attorney, gave that to DOJ, and then also forcing the Trump organization to turn over months of security footage from inside the former president's home. Think about that. So they could watch like sick voyeurs who is moving boxes in a storage room in the president's private home. This is how outrageous, outlandish this investigation is, and this is why DOJ and Jack Smith conducted it at DOJ in D.C. And Mark, at the last minute, said, whoops, we have a venue problem.
Now, we've talked about that here at length. Yep.
Exactly.
I've never seen this either. And you have a Department of Justice rule. It's a rule for federal prosecutors in their guidelines. It says you're not to do this, exactly what he did. That is to use a grand jury in one district and then move in a case where most of the events took place in another district. And she's asked the question. Now, the question is, what is the remedy? The remedy is to throw it out. Mm-hmm. Because the grand jury in Florida, which is where it's supposed to be, Julie Kelly, they didn't hear from any witnesses. They didn't see any firsthand anything. Anything. And, the government needs to be punished for such outrageous conduct, doesn't it?
I absolutely believe so, and I think that's what Judge Cannon is setting up. But the shocking news is that the D.C. grand jury is still working on the classified documents case. Now, why? None of the alleged crimes in either indictment cite that any of this conduct happened in Washington, D.C. The classified documents, the alleged willful retention of national defense information, the date is January 21, 2021, which means Trump was out of D.C. and back home in Mar-a-Lago. So why are they continuing to conduct this investigation in Washington, D.C.?
Mm-hmm. Because of what you said, of course. They'll get the result they want. I want to read something to you. This is from, let's see, Katie Pavlich had this on their site over at Town Hall. But I remember when this happened, too, April 2022, the New York Times. They did a whole big story on this, how Biden and his people were very disappointed in Garland. Let me quote, "The Attorney General's deliberative approach has come to frustrate Democrat allies of the White House, and at times President Biden himself. So they leaked this. As recently as late last year, Mr. Biden confided it to his inner circle that he believed former President Donald Trump was a threat to democracy and should be prosecuted, according to two people familiar with his comments. And while the president has never communicated his frustrations directly to Mr. Garland, he has said privately that he wanted Mr. Garland to act less like a ponderous judge and more like a prosecutor who is willing to take decisive action over the events of January 6th. So this is leaked, almost word for word. The scribes over there at the New York Times run it. Now, Garland didn't need this, but he's being given the go-ahead. Isn't this a message to Garland?
Oh, it absolutely is. And I mean, they were already looking at this to begin with. And I believe that article also talks about Lisa Monaco, the Deputy Attorney General, who, of course, is a longtime Obama loyalist, worked at DOJ for years, was Robert Mueller's chief of staff when he was director of FBI. So I believe that she was leading the charge on this, and I don't think they needed to signal much to Merrick Garland to get him going on this. But of course, Joe Biden has been involved in this and his advisors. So the idea that this is hands-off, that Jack Smith, who also is a longtime DOJ fixture, worked at Main Justice with Lisa Monaco during the Obama administration, that he is independent or not, doesn't understand his marching orders here. Of course he does. So it's going to be interesting to see the huge contrast in how both of these judges handle these cases, because you can see the difference already. And that's why you don't see many leaks coming out of Jack Smith's investigation in the classified documents case, do you, Mark? Because she already called out DOJ last year for leaking to the press.
Let me ask you a personal question.
Yes, sir.
Because this stuff affects me. I look at this, I look at what's happening to the nation. I think to myself, I don't think we're ever going to get back to where we need to be. That if they have their way, literally, this man will serve the rest of his life in prison. And Joe Biden will get reelected and will have 4 more years on top of these, what will be 4 years of this revolution against the American people. Some nights, it just keeps me awake. You?
It does. It does keep me awake. I think thinking about the other January 6th defendants and how their lives have been ruined probably kept me up more. But I think the only upside for me, Mark, after, losing a lot of sleep and waking up at 3 a.m. thinking about, what motion is coming next, is that the American people are awakening to this. It's very hard to come to terms with the deep corruption. That's not even the right word. The evilness of this regime and this Department of Justice. But I think people are seeing it right before their eyes, and they don't want this to happen. So to the extent they can do anything, I don't know. But this is going to be a real eye-opener for a lot of Americans, and it's necessary. And unfortunately, there's so much collateral damage, including Donald Trump himself.
Let's say she signs this protective order and Donald Trump violates. What is she going to do? Hold him in contempt and throw him in jail?
She could.
I mean, think about how ridiculous this is. Anyway.
Well, not only that, Mark, they're going to come forward with more superseding indictments. Jack Smith does not want either one of these cases to go to trial before the election. He absolutely does not. So they're going to bring more indictments in this case, just like they did in classified documents. But those superseding indictments will be very dangerous for the president and whichever co-conspirators they decide to charge with him for, say, seditious conspiracy.
All right, Julie Kelly, I want to thank you very, very much, and we'll keep bringing you back. You're a very clear voice on these issues. Thanks so much.
Oh, Mark, such an honor. Thanks for having me on.
Take care. Be well.
You too.
It's a very brave lady.